Right. So I see there's another question. I haven't joined a law school, but I'm planning to. Is there something I should keep in mind before that? Uh, See, I do think once you've made up your mind about joining a law school, your journey starts then, right? Uh, there's some disturbance coming. Is there an echo for all of you, or is it just me?
Tirthankar Mishra, can you please mute yourself?
Oh, thank you so much.
Yeah.
Uh, right. So, I do think no worries, no worries. Thank you so much for muting yourself again. Uh, right. So once you've thought that you want to pursue law as a career, I think your journey starts then. Um, So what we will be discussing today about how do you interpret a judgment, I do think you will find this quite useful because that is one thing that you can start doing before you join your law school because this is something that you're probably going to do until you're 90, right? You're going to have to read judgments until you're 90. Uh, and as daunting as it sounds, right? Even trust me, I'll be sharing some anecdotes from my journey as well, where I've had struggle when it came to reading judgments for the first time. Because to be very honest, if you look at most of the judgments, they're quite lengthy, right? And if someone tells you to read a 1,000-page document in one sitting, that can be very scary. It is scary for me as well, even in practice. Trust me, if I can run away from it, I do. But I do think that is something you will find useful today, and that's something you can start doing from day one before you join a law school. But that being said, if there is something that you need to keep in mind before you join a law school, is that never compare your journey with someone else's, because at the end of the day, we're all on different paths, right? Some of your colleagues in law schools, some of your peers will, go pursue a career in the judiciary probably, right? Some of them will go pursue a career in military. Some of them will go pursue a career in litigation. Some of them will join in-house as in-house counsels, right? Everyone, or some of them will even work with NGOs, and everyone will be on a different path. You will soon realize that once you graduate, a couple of years after, your colleagues who've joined big law firms have quit law altogether. So that has happened with me as well. A very close friend of mine from my LLM at King's had joined SAM Mumbai, and after a year he quit law altogether and now runs a cafe in Ladakh. So see, what I want, I'm not trying to scare you, but what I'm trying to tell you is everyone's journey is going to be unique, right? If we do not have the same goal or same destination, how can we have the same paths that we're taking, right? So before you join a law school, always remember that never compare yourself or how your growth has been to someone else's, right? And regardless of whatever you've thought with your life or what you want to do after you've done your degree in law, never think it is lesser or it is more superior than what someone else is doing, right? So that's that. Any other questions before we begin? I'd be happy to answer those.
Oh, sir, I have a question.
Yes, please.
Is it okay to join a tier 2 or tier 3 college, especially law college, and stay in cities like Mumbai or Pune and just try to get more exposure at least through internships because your college can't have good placements and everything.
Yes, absolutely. That is okay. See, at the end of the day, right, when you're at a stage as you are, right, when you're at the beginning years of your law school, I do think, there's this conception in everyone's head because of the peer pressure and whatnot that if you do not graduate out of, a top tier law firm, sorry, a top tier law school, you won't do well in your life, right? And that is a very big misconception. See, employers are concerned, right? They are concerned about your grades, of course. Your grades should be above average. But that being said, what college you did your degree from does not matter a lot if you have skills that are useful within the trade, right? So if let's say if I were on a hiring panel and if I saw someone from a tier two, tier three university, but who has done brilliant internships and know their way around drafting or legal research better than someone who comes out of a top tier college, then in that case I would be more inclined towards the person who has more skills, right? I understand when you're young. Even I had this misconception when I first joined law school that whatever law school you come from, it matters a lot. But quite frankly, it doesn't. Not at all.
So, but they also say that graduating from a good college or being from a very good college lands you to great internships and everything.
Right, that is there. But at the same time, uh, I would say, see, even if you work at a tier one law firm, right, and an intern at a tier one law firm and you're not able to make anything of that internship because let's say the work was hectic or the team that you were interning with did not allocate you work as much or did not look after you while you were interning or did not invest as much time in your learning experience, what you could have made out of that internship. In that case, I don't think a tier one internship would be as good for you personally, right? Because you won't learn a lot. But rather, when you compare it to a mid-size or a small or a boutique law firm where there is a smaller team, but there is a good, sort of working flow, in that case, if you are able to gain more experience there or more learning there, I think that internship is more useful. See, we all can get big names behind us and supporting us, but if we do not have anything to show for it, right, then it doesn't really matter. Okay, so Sakshi has told us that we'll have another separate Q&A session at the end of today's program. During that session, you can write your questions in the chat box and we can take them up once the speaker has finished. But right, if we're good to begin, then I do think we should begin. But if we're waiting, then I don't mind answering questions now as well. But I'll be happy to answer them later on. Don't feel like I'm only going to answer your questions right now.
Let's
Uh,
start the first session, sir.
all right, perfect. Okay.
Uh, Wonderful,
Uh,
sir. Thank you for, we are very thankful to having you, sir. So let's begin the session. Good evening, good evening, everyone. A very warm welcome to all the participants joining us today for our session, Case Briefing and Judgment Analysis. We are delighted to have all of you us with this evening. We will begin in just a moment. Before we formally begin, let me ask you a question. As law students, we spend years studying legal concepts, case laws, and procedures in classroom. But have you ever wondered how these concepts translate into real-world practice? What skills are truly required beyond academic knowledge? And how can students prepare themselves for a successful career in law? Today's session is designed to answer these very questions. This session will provide practical insights into case briefing techniques, judgments, analysis skills, and how to critically approach judicial decisions, helping students strengthen their professional growth and transition from law school to practice. About the call, let's take to you about the collective counsel. Today's session is organized by the Collective Council, a platform dedicated to bridging the gap between legal education and legal practice through practical learning initiatives, mentoring opportunities, skill based programs, career focused training. Our objective is very simple to help students and young legal professionals to develop practical skills, gain industry exposure, and prepare themselves for successful legal careers. It's now my privilege to introduce our esteemed speaker for today's section. Advocate Ujjwal Sharma Sir is a distinguished professional known for his expertise in legal research and case analysis and mentoring law students. Through this professional journey, he has guided numerous students and young professionals on understanding real world practice and skill building. On behalf of the Collective Council, I extend warm welcome to you, sir. Without further delay, I would like to hand over the session to Advocate Ujjwal Sharma, sir. Over to you, sir.
Thank you so much, Soumya, for that lovely introduction. And thank you all for joining in today. I really hope you're able to make the most out of this session and I'm able to deliver the standards that you're hoping to hold me up to. So let's begin, right? Am I clearly audible to everyone? Or do you want me to speak up a little? I do understand I've been told I'm a bit soft spoken. Okay, perfect. Right. So let me start with a very candid confession today. The first time I tried to read a Supreme Court judgment, I gave up halfway. And I mean, halfway is also a stretch. I gave up after reading 2 pages. I, quite frankly, I wasn't sure whether I was reading, law or if I was reading poetry or really complicated breakup letters between the parliament and the judiciary. And I know I wasn't alone when I was feeling that because reading judgments can be intimidating. Quite frankly, they're very long, they're full of legal jargon, and they're full of citations from other cases as well. Right. And sometimes, the sentence structures will make you think whether the writer or the typist was paid per comma to, to write that judgment. But here's the thing, being able to read and interpret judgments is one of the most important skills that you will develop as an early level law student and even more so as a lawyer. Right. This is where you see law in action. You see, statutes have given us rules or the broader framework or of how the society is supposed to function. Judgments, on the other hand, show us how these rules evolve, right? How these rules live, how they breathe, and sometimes even bend a little, right? So think of a judgment as a roadmap. It tells you where the case has started from, what the twists and the turns that it took, and where it ended up finally. If you learn to read this roadmap well, you won't just know what law is, you will actually understand why it is the way it is. One skill that I wish for all of you to learn today is you need to learn, see, everyone that you will meet will know what the law is. Even if they don't know what the law is, they can always Google it or like ChatGPT it. Okay. If I'm being honest, I'm sure more than half of you in this room have used ChatGPT to research a legal question before. You have, right? So everyone in this room has a way of knowing what the law is. Even laymen know what the law is. What you or you as a future lawyer need to know is you need to know why law is the way it is. And that is the important thing that will set you apart. Now, why do law students struggle with judgments? Let's hear it from you. What do you think, you know, uh, you struggle with when you're reading judgments? Have you tried to read judgments before?
Hello, sir. Yes, I have tried to read judgment before, and
What
I
did you
felt
personally struggle with?
sorry.
I was just asking, what did you personally struggle with?
Sir, firstly, though, when we read the judgments, now we feel it is very boring. We don't even understand single word. We just read, and read, and we feel that what am I? Am I even reading something? I'm not even understanding what is given in this, and it have quite complicated languages with the citations. That's all. And many a time I just quit reading the judgments.
Okay, thank you for that honest confession. Uh, yes, Nikita.
I personally had a hard time struggling with the language, but most of all, even when I could understand a sentence or two, it's extremely long. It seems like it loops back over points. And by the end, even if you understood them, each paragraph something individually, you're not able to put it all together.
Okay. Also, from now on, if you're answering, can you please tell me what year of study you're in so that I can put your response into a bit of a perspective. Thank you. So we had Anna and Nikita answer, right? Could you guys please tell me your year of study quickly?
Yes, sir. I am studying in third year BA LLB. Like I have
Third
just
year.
completed my second year
Okay.
and just entered in third year.
All right. Thank you. And Nikita, you?
I'm just entering law school, sir.
All right. Okay. Brilliant. Perfect. Does anyone else want to share their perspective or their struggles as to what they have been when they try to read a judgment? All right. Uh, so you see, from what I have understood from my years of experience and my personal struggles as well, because I completely resonate with Anna and Nikita, uh, judgments are quite confusing, right? So what the problem is and why so many law students struggle with reading judgments is one reason that I've, in my opinion, is that they start reading from page one and try to understand every single line immediately, every single word immediately, which is like trying to watch a mystery movie by focusing only on the wallpaper in the background, right? Don't worry, we'll come to this as to where you should start reading a judgment from and how do you read a judgment and how do you actually navigate through this roadmap. Uh, but before that, let's try to understand what all problems there are, right? Second, I think quite often than not, and this is what I've seen with my set of interns as well, they confuse the main holding with the side remarks, and often the side remarks as the main holding. And you would have noticed that ChatGPT does that too, right? AIs, even legal AIs do that. What they do is they confuse the arguments that were made by the parties with the finding of the case, right? Has anyone noticed that before here? Yeah. So that is another thing. The third thing is students often skip context, which means they miss the point entirely as to why was this judgment brought, in place. So today I want to make this process simpler for you. In the next hour or so, we're going to break down the judgment into manageable parts and learn how to spot the most important sections of a judgment and figure out how to extract the legal principles, what the ratio of the judgment was, without drowning in, all the citations or all the legal jargon that is there. So let's try opening a judgment in our mind and seeing what's inside, and let's discuss the anatomy of a judgment. So every judgment, be it from the trial court or to the Supreme Court, will always have a structure. The style may vary slightly based on who the judge is or what the court is, but certain elements appear almost every time. Now you need to learn how to spot them so you can navigate even through the most complex judgments. The first thing that you need to figure out is the header. Now, this is usually the cover page, which will tell you the name of the case, if there is a citation to it, the name of the court, the date on which the judgment was given, the name of the judges that had delivered the judgment or the bench. Uh, do note that whenever you're reading the bench strength or the bench name, always note what the strength of the bench was. So, a constitutional bench judgment. Can anyone tell me what a constitutional bench is? How many judges are there in a constitutional bench?
I believe there will be more than two judges, right?
Actually, not 12. I see there was a response. Okay, so I guess I'll leave this open-ended. There is a very bad habit with me. I never give answers. Uh, but, this is something to think about. Constitutional bench uh, carries more weight than, a division bench. Okay. Does anyone know what a division bench is? Or how many judges are there in a division bench?
two judges.
Absolutely. So the first thing that you need to focus is on whenever you're reading a judgment, or the first part that you need to identify is the header, which will carry the name, citations, court name, the date of the judgment, number of judges, name of the judges, and who the lawyers were as well at times. Then comes the procedural history part, right? Now, this is the origin story of the case. How did it reach the court? Take it. Was it an appeal from the High Court? Was it a writ petition directly filed under 226 or 32? This helps you understand what the scope or how big the scope of a judgment can be, right? Obviously, if you're reading a first appeal as compared to a writ petition, the scope that the court can exercise in that first appeal will be limited when compared to a writ petition, right? Because under writ matters, courts enjoy a much wider power. Is everyone with me on that? Yes?
Yes, sir.
Okay, brilliant. Thank you.
Yes.
So you need to first identify what the origin story was. How did the case reach the court? Second, or sorry, the third part that you need to look at are the facts of the case. Now, this is the narrative. It is the who did, what did they do, when did they do it, why did they do it, where did they do it. The judges usually summarizes the facts before moving on to the law. So in a judgment, whenever you're reading a judgment, you would notice that before the law part of the case is discussed, every time the facts would be discussed. So in your head, you can, even if on the page it is not separated, right, or only separated by paragraph breaks, in your head you can always color code these things. I usually, try to color code these things in my head so that I know what part is talking about what, right? That actually helps. Now, you need to pay very close attention to this part, right? The facts of the case, because the ratio often depends on a specific fact. Does anyone know how precedents function? What precedents are? Could anyone please tell me what precedents are?
It's like a previous case which had maybe similar circumstances or similar elements, and the ruling or the outcome of that case will be used to set that mark for future cases like that.
Absolutely, absolutely, spot on. So, um, for those who are not aware, precedents are basically the principle that a similar fact situation, if has already been decided, it will be decided in the same manner again. The sole reason behind doing this is to create predictability in law, so that when similar circumstances are presented again before a court, a different verdict is not given by the same court, right? Because law at the end of the day needs to be predictable. It needs to be stable, right? So precedents are only created where there are specific facts involved, similar facts involved. So that is why we need to very carefully know what the facts of the case are. Then comes the part of the issues that are framed, right? After the facts are discussed, you will see where the judge will talk about what the question or the legal question was placed before them, right? This is one of the most important bits because the court usually states the precise legal question that it needs to answer. Think of this as an exam question, right? Everything else or everything else in the judgment is building up towards answering these questions. Then comes the part where the judges will discuss what the arguments by the parties were. Now, what you need to know is just because a judgment has discussed certain arguments doesn't mean it has accepted these arguments, right? More often than not, you would see a judgment where arguments have been discussed by the parties. What all cases they relied on have been discussed by the advocates of the parties, and later on, the judge has said that though very valid, these arguments cannot be accepted, right? For so and so reason or whatever reason the judge might give. So this is the part of the judgment where summaries of what each side argued is discussed. You will often find a lot of citations in this section because to be to be very fair, we lawyers we do love digging up old graves to support our points. Don't get lost in the list. Focus on what the logic was, right? What is the point that each side is trying to make? And then comes the part which is the reasoning of the whole judgment or the court's reasoning. This is the heart of the judgment. Reasoning usually starts by explaining what the law is, then applying it to the facts, and then finally reaching a conclusion. This is the IRAC method. If you guys, you would find a similarity between this. Does anyone know what the IRAC method is of answering questions? First years? Yes? Right. I remember I was taught IRAC in law of torts. That was the first subject that taught me how to apply IRAC. Now, yes, brilliant. Thank you. So the court's reasoning will first explain what the law is, then apply it to the facts, and then reach a conclusion. Now, within this reasoning, you will find two important things. Can anyone tell me what the two important things are within a judgment? You would have been taught this when you were preparing for CLAT or your law entrance exams, and in your legal methods first year.
Facts.
Ratio and arbiter. Yes, brilliant. Thank you. Which one of these is binding out of ratio and arbiter? Ratio. Brilliant. So ratio is the binding legal principle that is created out of a judgment. And arbiter means arbiter dicta stands for observations made in the passing. Now these are not binding, but they do hold a very persuasive value, right? So when later on, let's say slightly identical situation arises, and it is different on let's say one or two aspects for a precedent to not apply, you could make an argument based on the arbiter, right? Because at times the judge would pass a very persuasive um, pass a very persuasive judgment about if let's say facts were a little different than the present case, then we would have not arrived at this finding, right? So orbital dicta basically means observations that are made in the passing. Can anyone tell me what comes after this? Bonus points for anyone who could. There is something that is very important that is often rarely talked about in law schools that comes after this. Anyone wants to take a guess? Analysis? No, that's unfortunately not the answer that I'm looking for. Maybe the enforcement? A bit warmer, I say, but still not there. You're a bit warmer. Close. Anyone wants to take a guess? No, not it. All right. If all of you have given up, yes, the final judgment. Sakshi, you've hit the nail right on its head. The final judgment, right? What is the outcome of the case? Who wins or who loses, right? And what the court directs. So, enforcement, I'm so sorry. Enforcement was a bit close. It is what the court directs. So, always check this first when you begin reading a case, right? This is where you need to start from. So, can anyone tell me why would this be, a good starting point? Anyone? This is a good starting point because once you've read this, this puts the whole judgment into a good perspective. Absolutely. You know the flow of the judgment. You will know what the outcome and how the court came to its process. You will already have that sort of a preconceived notion in your head when you're reading the judgment again, right? Now, to give you an example, if a judgment were a movie, you would see the header as the opening credits, the procedural history as the prequel, the facts as the first act or setting, setting of the scene, issues as the central conflict, arguments as the dialogue that is there, reasoning as the climax where the truth is revealed, and the final order as the closing scene with the audience applauding and everything. So once you learn to quickly identify these facts or these parts of a judgment, uh, half of the job is done, right? Because a judgment would then stop looking uh, that daunting of a task to complete, right? Because you can then easily create summaries to a judgment. So we've talked about what, the puzzle of a judgment looks like. But here's the actual question. How do you read it in a way that makes sense and does not take away your entire weekend? Let's be honest, right? When you first read a 150-page judgment, it feels like the judge was, competing for the Booker's Prize for the longest sentence. You start with good intentions. You take out your different colored highlighters, blue, green, and orange, perhaps. And then somewhere around page 7, you're wondering if you should have just read the head note of the judgment and pretended that you read the entire judgment. Now, let me tell you, there is a smarter way to read the judgment. Reading judgment efficiently is not only about reading it uh, with a method, uh, it's more about understanding what the context was, right? So, as I've already told you, step number one, and this is, I would say, a seven, yes, a 7-step, program that I usually follow, a 7-step process that I usually follow. The step number one is start from the end, as I've already told you, right? Go straight to the conclusion. Find out who won, who lost, and what did the court actually directed. Why? Because knowing the outcome helps you understand the reasoning and the context in which that reasoning was made, right? So it will help you. It will help you not think of a judgment as a mystery anymore, right? A mystery novel that you're reading. So, for example, if you read the Navdeep Singh Johar case, from the final paragraph, you would already know that section 377 was partially struck down, right? Then when you go back to reading the reasoning, you will spot exactly how the judges have built up to the conclusion. Okay. So that is step number one. Start from the very end. Step number two is after you've read the direction of the court, what I need you to do is I need you to identify the issues that were framed, right? Find the list of issues or the question of law that was before the court. Most good judgments, you will see that these questions are already stated in a very clear manner. Quite often than not, you might even find them in bullet form or a numbered paragraph. Now, this is your roadmap. For instance, if we talk about the Maneka Gandhi judgment, the key issue there was, does the right to personal liberty under Article 21 include a guarantee of fair, just, and reasonable procedure? Right? Now, once you know that, you can ignore the long digressions that are there in a judgment, or you can ignore the passages which do not actually focus on answering this question. Does that make sense? Is everyone with me? Any doubts so far? Okay, brilliant. Thank you. So, coming to step number 3 now. Step number 3 is separate the facts from the reasoning. Now, this is a big one. Law students often get lost because they can't tell what the judge is, whether the judge is narrating the facts or they're trying to actually interpret the law. Facts tell you the story. These are important because the ratio is tied to them. But the legal reasoning is where you find the principle that was, built. Here's a tip that I often use. Whenever you're reading a judgment, put a small F in the margin next to a fact heavy paragraph and put a little R for reasoning in a reasoning heavy paragraph. Okay, it's like tagging your own notes on your phone. Yeah, it makes it easier for you to come back to it later. Step number 4 is extract the ratio, the holy grail of the whole judgment, the ratio. This is the binding principle of the case, and it is not the whole judgment that is binding. Now, if you distill this rule of law that the future courts must follow, half of your job is done. Finding the ratio is a skill that you will need to acquire with time, right? With practice. Whenever you're faced with a dilemma, whether a particular, I'm so sorry, whether a particular part of the judgment is a ratio or not, you could ask yourself 3 questions. First one, whether the legal question second, happen the same that's not ratio of the case, right? If the principle would still apply, if let's say facts was, if after answering all of those 3 questions, if the principle that the courts have given would still apply, you have found the ratio. Okay. Remember, remember that ratio is like the main dish. Everything else apart from that, like the orbiter, the reference, the background, it's just an appetizer. Uh, okay. If I could please repeat the third question. Yes, the third. uh, Okay, some of you are confused about the third step. The third step was separating the facts from the reasoning. You put an F next to a fact heavy paragraph, you put an R next to a reasoning heavy paragraph, right? Within the margin with a pen. The 3 questions that I told you in step number 4 when you're trying to extract the ratio are firstly, what legal question was the court answering? What principle did it apply to answer it? And thirdly, would the decision be different if, let's say, the facts were slightly different? Okay. Now, the fifth step that you need to do is everything clear up until now? Yeah. Okay, brilliant. Thank
Sorry
you.
to interrupt, sir, but I would
Yes.
like to know about more about the extraction of the ratio. I didn't understand that point.
Okay. So basically, you're trying to extract what the yes, sure, I'll go a bit slow. Uh, Basically, what you're trying to do is you're trying to see what the court wanted to, give as a principle to the question that was before them. At the end of the day, what is a ratio? Ratio is just the court's answer to a legal question that was placed before them. If that question has already been decided, then a precedent would apply. Then no new ratio would arrive, right? But if that particular factual situation has not been decided up until now, or there is a new legal question before the court, in that case, a new ratio is formed, right? So when you're trying to extract, you ask 3 questions to yourself. If, let's say, you're confused whether a particular sentence or a paragraph would form part of the orbital or if it is the ratio, you will ask, what legal question was the court answering? What principle did it apply to answer that question? And would the decision have been the same if the facts were slightly different? Okay. If your principle would still apply, you found the ratio. Correct? Okay. Now let's come to step number 5. We have 2 more steps remaining. After 5. Step number 5 is spotting the orbiter. Now, orbiter are, as I've said, are observations that are made in the passing. Now, they may be brilliant, they may be insightful, they may even be poetic, but they're not binding. For example, in Keshwananda Bharti, there are several comments that are made about democracy, about governance, that are not, part of the binding principle in Keshwananda Bharti decision. But they've been quoted for decades in debates, in academic writing. Now, think of Orbiter as a great piece of advice from your senior who, gave it to you over coffee. There is a question. Sir, could you please repeat step number 2? Sure. Let's do one thing. Let me just complete all the steps and then I'll repeat all the steps one by one again. Yeah? Okay, perfect. So Orbiter are, they're comments that are made in the passing. They're great, they're brilliant, they're very insightful, but they're not binding. Okay. They still hold a very high persuasive value. Cool. Everyone clear about Orbiter? Not much, not a lot of difficult stuff here. Step number 6 is check the citation and how they're used. Now, lawyers, judges, everyone, they love, citing cases to support their reasoning. Don't just jot down the case name when you see the next citation. See how they're being used within a case. Okay. Is the court following a precedent? Is the court overruling it? Right? Is it applying it by modifying it slightly? This will help you see how the evolution of law has taken place up to that point of the judgment. Okay. Now, here's a caution. Whenever you see head notes in law reports, they're very often an oversimplified version of how the precedent was applied. Always read the relevant paragraphs yourself. Whenever you're reading a head note, you will see a paragraph number at the end of the head note. Yes, have you guys seen a head note? Yes? Right. Neutral citation system. Let's take that towards the end, if that's fine with you. Because I do see it's 8:16 already, and we have 2 more steps. Right? So check how the citations are done, how they were used. Were they applied straightforward? Were they overruled? Or were they modified slightly? There are only 3 things a judge can do to a citation that has been referred to. Now, let's come to step number 7. That is the final step. That is connect the ratio back to the statute. Once you've got the ratio, once you've read the entire case, link it back to the statutory or constitutional provision that that the ratio is interpreting. If let's say it is section 7 of the Contracts Act, understand how this judgment clarifies or changes the interpretation of section 7 of the Contract Act. This will make you way more confident when you're using that particular judgment in your own legal arguments later on. So let's now look at all of the steps that we've covered so far. Okay. Step number 1, you start from the end, you read what the court has directed first, and then you go from there. Step number 2 is identify what the issue was and what the issue was framed. Step number 3 is separate the facts from the reasoning. Okay, do not confuse the facts or the reasoning because it happens quite a lot. And the tip that I gave you, use F next to a paragraph which is very fact heavy. Use are next to a paragraph which is very reasoning heavy. Okay. So sorry, it's been a long day. Step number 4 is extract the ratio from the case. Step number 5 is spot the orbital. Step number 6 is check citations and how they're used. And step number 7 is connect the ratio back to the statute. Step number 7 is very important. It might not seem important in reading a case, but it is very important because that is what reading a case, that is what will make reading a case useful. Because if, let's say, you've read a case, but you do not know how it applies to the statute in real life, then what good has it ever served you, right? Now, that, in my opinion, was one the breakup of or the puzzle of what a judgment looks like, and two, the step-by-step approach to reading a judgment. Did you notice what we did not do here today? We did not just get stuck reading one line or page number one, line number one, like a judgment is a novel. We started from the end. We found what the issue was. We separated the facts from the reasoning, and we extracted the ratio. And then we all, identified the orbital. We checked the citations and tied it back to the statute. Now, this method turns a judgment into a more, manageable task that you can actually use in your exams and moot courts and eventually in courts. Okay, someone has asked, can you please repeat step number 7? Sure. Step number 7 is connecting the ratio back to the statute. Once you have found out what the what the statute is trying to say, or what the once you found out what the ratio of the judgment was, you need to tie it back to the statute and the constitutional provision. So the example that I took was, if let's say there is a case that discusses section 7 of the Contract Act. Once you've figured out the judgment, once you've understood the judgment, you need to go back to section 7 of the Indian Contract Act and see how that particular judgment now affects you know, now provides either a clarification of changes in the interpretation of Section 7. Okay, so this will make you more confident about your own legal arguments when you make them. Okay, I think that brings us towards the end of our session. Now let's open the floor to questions. Thank you.
Sir, how many judgments should we read in a day? I'm not in a law school yet. I'm school going to join. So how many judgments should I read in a day?
See, I'll tell you, we all are quite ambitious about this, and I'll be very honest, even us lawyers were very ambitious about reading at least one judgment a day. But let's be honest, life gets difficult, life happens, right? So you might not end up reading a judgment a day, but as long as you're able to keep that going, right? Even if, let's say, over a weekend, 3 days, you've read one judgment, that is still good, right? Something better than nothing. So even if you take 2 days to read one judgment, that is absolutely fine. I won't say there is a fixed number that you must read one judgment a day. That is a good practice, right? But there isn't a must in anything in life, right?
So there was again a question, many about the same law school which I asked during the beginning of the session. Is it like fine, or will I actually get placements if I want to do corporate law and I'm in a tier 2, tier 3 college?
Yeah, definitely. See,
So I have to
even
focus.
if, let's say, sorry to interrupt you, even if, let's say, you do not get, when the time of placement comes, you do not get the tier 1 law firm that you were hoping to get, right? Because at the end of the day, it is like nothing is guaranteed, right? So even at the end of 5 years, let's say you get a tier 3 law firm, I would say get that job, take that job, right? Why? Because you can always switch, right? It's not like your career would end after a year or two of graduating. You always have that option of switching and moving up. That always happens. You can always move to a
Thank you.
better.
Thank you, sir.
Yes. So I see there are a lot more questions here. Uh, so if I were to start reading case laws, where do I start as I'm going to join law school? Right. I would say there are different platforms. There's Indian Qanun, which is a free one, but once you do get a law school, um, your law school should provide you access to SCC, Manupatra, even live law, and bar and bench could be good sources. Be that as it may, even if you go to the Supreme Court website, you will see landmark cases there, right? So you can read cases there as well. Manthan has asked, can you suggest platforms for finding relevant judgments? Right, relevant judgments can be found everywhere, even at the High Court website. So with the Delhi High Court website, there is an option to conduct a free search of a judgment that has been rendered by the Delhi High Court. So you can actually, search for a judgment using keywords. That could be one place. Relevant judgments can also be found on the Supreme Court website itself, as I've mentioned just now. Right, different high courts also publish their journals, which is free of cost to access, or the online version of it. So every year, like there are at least 3 or 4 journals that come out from most high courts, which tell you about the landmark or notable cases from their reportable cases from that particular high court. So that could be one, place where you can look for questions. Sorry, look for judgments. Right. And there's what is the next question? Where, from where to read? Can you show us with an example how? I would have loved to, but I do think we are at a crunch of time, so I won't be able to show you. But you can read judgments. You can, even if you post, there's more than a chance you will hit a judgment. There are so many available for free online. Uh, can you tell us about your experience as a panel advocate, its benefit, and how different is it? It's very different than regular practice because panel advocate is like it's like a lawyer on retainer with a particular department, right? So you only do that in department's cases. You're on a retainer with them. You do not appear against them. You do not appear, where there could be a conflict.
So,
Yes.
can you share your experience that how did you deal with the competitive world of law school when you were young?
Uh, Firstly, I'm still very young. Thank you very much. But uh, how did I deal with the competitive market? See, again, at the end of the day, there are certain skills that will set you apart. Obviously, each person, each one of you present in this room today can do something better than the other one, right? While you may not excel at everything, you will definitely be good at something, right? If you're if you think that you're not good at something, you probably haven't found out what you're good at. So there's still more searching to do there. So what I will tell you is focus on that one or a particular set of skills that set you apart. And trust me, as scary as it sounds, and as unbelievable as it might sound to 50 years, placements are not the end of your world, right? No worry about that. Okay, there's a lot of questions. Does that answer your question?
Sir,
Okay. Uh, how do we learn about case briefing? Case briefing method that I told you, right? The anatomy where you identify the facts, you identify the issues, that is basically case briefing. Once you do that, what you have is a summary of the case. Okay, perfect. Can you please explain in short? Then could you please expand on your question as to what were you looking for me to answer, or has your question been answered? Uh, let's move on to the next question. Is it true that pursuing a BLLB is only worthwhile if you're from a government law college? No, that is not entirely true. As long as you're able to have the skills, or you're able to, build the skills, I don't think a college matters really. At least not in the longer run. It might matter in the short run, right? For your first job, it might matter what university. For your second job, or once you've have gained that experience 2 3 years time, I think anyone is going to ask you what college to do. I would prefer if you guys could please unmute yourself to ask questions. That is, also fine. If you could raise your hand and how detailed should a case brief be for exam preparation versus internship work? Right, for an internship work, I tell you, a case brief should not be more than a page. Exam perspective, I think it should be even shorter than a page, because there you do not really need, you will have to learn a bit. थोड़ा याद रखना भी पड़ेगा. So you might have to remember, what the facts were, because you can't keep writing everything. That you end up with what, thousands of pages of notes.
Sir, I have shared a link of YouTube. I follow it. It is Delhi. It is posting Supreme Court and High Court judges. Like we should see it there. But I have shared the link.
Yes, let me quickly have a look at it then. I do think this is good because it is giving you certain, cover ups from the court. So should not be an issue following it. As long as you're updated about what's happening within the legal world, that's not an issue. You should follow it. That's a very good thing. I think how to connect with you can always LinkedIn, if that's correct. If you guys want, I can drop my LinkedIn here if that is helpful for everyone. It'll just take a second. Give me a second. Okay, that's my LinkedIn.
Sir, I have shared your profile.
Oh, brilliant. Thank you so much. Right. Very helpful. Is it okay to pursue law even if you don't know what you want? It is okay to pursue law even if you don't know why you want to do it. You can always figure out. Plus, if you pursue law, that doesn't mean you have to stick with being an advocate after you graduate. There are multiple options, career options that are still available. A lot of lawyers go into business, venture out, do an MBA, and venture out completely into business altogether. Some of you venture out into all of that, those sort of work. Think work. A lot of you might even go prepare for competitive exams like UPSC and judiciary. So even if you figured out why you want to do law, but you just want to do it, it's fine as long as you're doing a step ahead. See, I personally am very biased against online internships because I learning there gets lost in online format and you're not able to communicate as freely as, or you're not able to learn as freely as you would within an offline setting. But I'm not sure whether you would find some good online programs. Maybe talk to this. At least during my time, that was still relevant. I'm not sure if they still post, but good source. Can you please explain how to know assessment is with certainty? Like any website, find judgment, it is written, it is below. So website, obviously there is Manpatra. On Manpatra, they do say if a judgment has been over. Same with case mine. If you've used it, case mine about result. When you open a judgment, it will tell you feedback form.
So
Yes, so sorry to interrupt you.
Sir, we would love to know about your journey.
Sure, let me just quickly uh, to answer.
Yeah, sure, sir.
Uh, Sir, in which so I practice before the Madhya Pradesh High Courts, and this uh, sir, does BPLLB have a it's these days you so it doesn't really matter what you're doing. Um, yes, please fill the form, guys, for the certificate. What are do while doing case briefing? What common mistake, right? One common mistake that I told you is they confuse what the relevant part of the judgment is, whether it ratio or whether it would operate as a precedent or not. That is a common mistake. So they often confuse arguments that were made than with the applicable part.
Sir, I have a doubt. I saw on your LinkedIn that you have pursued your degree from King's College London.
Yes.
Even I wanted to give LNAT UK and LSAT with CLAT this year, but my parents are skeptical that I won't be able to come back and practice here.
Yeah. No, you definitely can. Like, which is a foreign lawyer's bar exam, which is slightly different than have to complete a course on as the requirement maybe it might differ for jurisdictions that you've completed. You might have to complete a course on ethics because that
Okay.
is usually the case with different jurisdictions. But that is a different bar exam that you have to sit for.
Will it take a long time to get adapted here?
That is right because see, it won't take a long time to finish your degree because LLB outside the UK is just 3 years, right? You don't need to do you can just get done with it in 3 years. Adapting here would be a bit difficult. Law is more or less the same, but you will have to spend more time if in future you do intend on moving to India permanently.
Would you suggest doing law from UK or US? Like
So I
going
would not.
So,
abroad?
for example,
US, I would certainly not. Like that is again my personal bias against that. But UK definitely. I don't see like if I could have done something differently, I would have done my undergrad from
Thank you, sir.
that. Quit my job in the UK and come back to India. That is
so one of the reasons why we don't want to practice advocacy, like, is because advocates, especially first generation lawyers, they don't get paid that much. And for example, if we have some of the interest, even that interest, parters away because there is no good pay. So if we become an in-house,
it's a good option, a very good option.
so we can get a decent pay, at least if we are in the in-house.
Yeah, definitely. Uh,
So
Also, don't worry. Pay is good. Like you haven't started your law school yet. You're worried a lot about how it will end. I would say, see, it's always very good to be worried about your future, right? Your 5-year, 10-year plans. It is very good to be worried about those. But you are going to have worried of yourself. Because trust me, as much as I want to go back to law school now, I can't. Right?
thank you, sir. Thank you so much.
Don't worry, everyone gets a job after law school. Literally everyone gets a job after law school. Yes. If there are no other questions, I really enjoyed your session as well, but I think we will have to, because I see Soumya is a bit pissed that we've stressed it for a long while now. Okay. Perfect. Thank you so much for your time.
Thank you
And
so much for that insightful and engaging session. I am sure our participants now have much clearer understanding for case briefing and judgment analysis and what it takes to build a successful career in law. As we come to end of today's session, I would like to extend our heartfelt gratitude to Advocate Ujjwal Sharma sir for taking the time to share valuable experience, practical knowledge, and insights with us all. Before you leave, we request you to kindly fill out the feedback form that will be shared in the chat box. Your feedback helps us organize more meaningful and impactful sessions in the future. And now let's take a virtual photograph. I request everyone to kindly switch on their cameras and join us for a quick picture.
guys, if you could turn on your cameras, that would be great. I would love to have a picture with all of you.
Please, I request all you to switch on the camera as soon as possible as we are running out of the time. Okay, thank you for thank you everyone for joining us today. We look forward to see you all again in our upcoming sessions. Have a great evening ahead and stay connected with the collective council. Thank
Thank
you.
you so much, guys. Bye bye.
Good night.
Take care.
Thank
Good
you,
night.
sir.